Hi, I'm Rusty Adams, and I'm the research attorney for the Texas Real Estate Research Center. For the winter issue of Tierra Grande, I wrote on as-is clauses. These are very common in Texas law, and there's a few main points in this article. First of all, as-is clauses are generally enforceable, and then there are three exceptions to those as-is clause, to the enforceability of the as-is clause. First of all, an as-is clause says that the buyer is accepting the property as is. And it's important to remember that this is a bargained for clause. And so the buyer accepts the risk that the buyer's assessment of the property may not be correct. So if the buyer is wrong about the value of the property, then the buyer will not have any recourse against the seller. The way this works in Texas law is that when there's an issue with the property and the buyer wants to pursue a lawsuit against the seller, they would have to prove that the seller's actions caused the buyer's damage. And the way an as-is clause works is it negates that causation. Texas courts are strongly committed to freedom of contract, and so they usually will enforce an as-is clause. There are three exceptions to the enforceability of an as-is clause. The first is the fraudulent inducement exception. And what this means is that if the seller has used fraudulent means to get the buyer to agree to the transaction or to agree to the contract that contains the as-is clause, then the as-is clause will not be enforced. The second exception is the impairment of inspection. So if the buyer has the right to inspect the property but is kept from doing so by the seller or the seller's actions, then the clause will not be enforced. And third, the court will look at the totality of the circumstances and determine whether the clause should be enforced. For instance, the court will look at the sophistication of the parties. The court will look at whether the buyer was represented by counsel. And in particular, the court will also look at whether the as-is clause was part of what's called boilerplate. In other words, it's considered relatively non-negotiable and it's inserted in the contract. Interestingly, there was a case where the court looked at the as-is clause in a TREC contract. And the as-is clause was put in the form of some check boxes. And it said, buyer accepts the property as is, and had alternatives for what box would be checked. And because that was a decision that had to be made, and because that was a part of the bargain between the buyer and seller in entering into that contract, the court said that by definition, that was not boilerplate. And so the court will look at the totality of the circumstances, and the basic gist of it is the as-is clause is generally binding. However, if the seller does something that is fraudulent or obtains agreement to the contract by fraud or prevents the buyer from having a reasonable opportunity to inspect the property, then the court will not enforce the as-is clause. To learn more about as-is clauses, read my article, A Clause for Concern, in this winter's edition of Tierra Grande, or on our website.